Encore performance. Prince Harry takes the stand in the courtroom. A recent judgment by a judge delivers a significant blow to Prince Harry in his legal battle against Associated Newspapers, but the outcome is not determined until the final verdict. Hello, with all the regal splendor, we warmly welcome you to the Princess Diana News channel. Now, let's get to the video. Prince Harry's unforgettable court performance last year involved him passionately expressing his affection for his ex-partner, Chelsea. He made claims about being aware of his phone being hacked, despite lacking any concrete evidence. Interestingly, upon reflection, it turns out that during one incident he alleged his phone was hacked, he didn't even possess a mobile device. In other words, the entire testimony was a complete catastrophe. Thanks to a recent judicial decision, it appears that we'll have the opportunity to witness Harry's testimony once again in court. This lawsuit is directed towards Associated Newspapers Limited. They are responsible for releasing the Daily Mail, the Mail on Sunday, and the Mail Online. In an attempt to avoid a trial, they sought to have this case dismissed during a hearing held in March. According to PA Media News Agency, they argued that the legal challenges had been filed against them well beyond the appropriate time. And ANL has strongly refuted the allegations made against it. A group of claimants, consisting of individuals like Harry, Elton John, and Baroness Dorian Lawrence, has contended that ANL deliberately kept important information hidden, and this was not something that could have been discovered earlier. ANL has consistently denied this, but Justice Nicklin has stated that ANL did not succeed in decisively refuting any of the claims made by the claimants. He reached the conclusion that the collection of individuals possess a genuine potential to prove that ANL did in fact hide the necessary information that could have enabled them to make their allegations earlier. Currently, there are individuals who view this as a victory for Harry and his group. On behalf of the claimants, Hamlin's law firm expressed their satisfaction with a recent decision that permits the advancement of our claims relating to significant criminal acts. ANL is alleged to have engaged in reprehensible and unlawful acts, which involve the utilization of private investigators to surreptitiously place surveillance devices on individuals' vehicles and residences, intercepting telephone conversations, and unlawfully obtaining confidential medical records. The speaker asserted their determination to reveal the truth during the trial and ensure full accountability for those connected to the newspapers involved. A statement has been released by ANL, in which they categorically deny the allegations made against them. The assertion dismissed the allegations as highly sensational and utterly absurd. Upon initial observation, it may appear evident that Harry and the other individuals making a claim have achieved a decisive victory. However, it's not as straightforward as it may seem. Because according to the Daily Mail, Justice Nicklin has remarked that permitting the present state of their case to proceed would constitute an abuse of process and could tarnish the integrity of the justice system. Smartly paraphrased, the individual's viewpoint is that the 7 people who allege being hacked by Associated Newspapers have the potential to proceed with their cases in court. They have dismissed the newspaper group's request to have the cases dismissed. However, he also mentioned that a considerable amount of public interest exists in barring the claimants from utilizing classified papers in defiance of a Leveson inquiry order issued a dozen years ago. Therefore, it is possible to witness the entire scenario unfold once more, wherein Harry asserts these allegations, yet lacks any evidence to support them. Due to circumstances, Harry now encounters a similar predicament with his child. Reportedly, essentially all the proof originates from the ongoing Leveson trial. Therefore, the confidentiality of those documents would have been breached by his attorneys. If that were true, the event that Harry alleges occurred would have occurred prior to 2013 regardless, and the legal case would be time-barred. Harry plans to find proof indicating that the act of eavesdropping took place after 2013. However, considering the lack of evidence, similar to what occurred with the son, it is highly likely that he will once again embarrass himself in the witness stand. It is expected that ANL views this as extremely positive news for their organization. With open arms, as he joins our team. Justice Nicklin ruled that the information provided by us and other newspapers to the Leveson inquiry, under strict confidentiality, continues to be bound by the restriction order set by Lord Justice Leveson. A noteworthy triumph for fairness and postal services occurred as the judge decided that the claimant's use of the information was improper and therefore should be eliminated from the case. As Mr.in his ruling, Justice Nicklin deems this to be an oppressive procedure that could tarnish the reputation of the judicial system if employed. In the given statement, it was emphasized that the allegations of phone hacking, landline tapping, burglary, and the use of concealed microphones made by Prince Harry and others are completely absurd. The Speaker confidently expressed their anticipation for disproving these claims in a court of law at the appropriate time. We deeply appreciate the judge's thorough examination of our applications. The claimant's party consists of notable figures such as Harry, Elton John and his spouse David Furnish, as well as Elizabeth Hurley and C.D. Frost, Sir Simon Hughes, and Baroness Dorian Lawrence initiated legal action last October, citing the testimony of a private investigator, Gavin Burrows, who confessed to various illegal activities including phone hacking, wiretapping, and vehicle surveillance, as the basis for their case. Eventually, Mr. Burrows denied the allegations of admitting to hacking for Andel when he addressed the court. He labeled those assertions as untrue, resulting in the judge advising Harry and the others to potentially revise their anticipated outcomes. In March of this year, ANL submitted several applications to the judge, including one that raised objections to the claimant's utilization of financial ledgers from the publisher of the Mail titles. These ledgers had been presented to the 2011 to 2012 Leveson inquiry into press standards, following the established protocol of the inquiry. The documents were deemed confidential and the chairman issued a directive stating that the documents should not be revealed or made public. However, the issue lies in the fact that these specific documents are crucial for Harry to substantiate his argument. Once again, history will repeat itself with the same outcome for the Sun. Harry will ascend to that place and confidently assert numerous statements. He will eloquently express his deep admiration for Chelsea. Afterwards, he will be requested to present substantiating proof for his assertions, but unfortunately, he will lack any evidence. Celebrities, including members of the royal family, have a valid explanation for their decision not to take legal action against the media. The media possesses a plethora of information about Harry that he wishes to keep confidential, but it seems that he remains oblivious to this fact due to his own pride and Meghan's self-centeredness. I believe he remains firmly convinced that he will achieve a decisive victory, although that is not the case. He is under the impression that everyone will finally perceive him as the true victim. However, this is an unlikely outcome. Actually, there is a plethora of highly provocative information concerning Harry that may surface during this proceeding, and it is safe to say that he will be deeply disconcerted by it. Harry alleges that his personal privacy has been violated, yet his actions in the witness box contradict this claim. While individuals like Elton John and others are also implicated, the media's attention is primarily directed towards Harry. Harry is unlikely to be receptive to having his personal life scrutinized and open to investigation. If Harry had been more intelligent, selfless, and humble, he would have resolved this matter earlier, following his brother's example in 2020. Prince William experienced an abundance of hacking incidents, surpassing 100 occurrences, while his brother, Prince Harry, had a less frequent experience with only 11 hacking incidents. Prince William received a substantial sum of money which he promptly gave away to a charitable cause. Harry also had the choice to accomplish the same task. However, he declined and stated his preference for pursuing separate legal action. In other words, that choice was extremely foolish. Sherburne, the attorney representing Harry, had the privilege of being significantly involved in the case, granting him ample opportunity to both witness and comprehend the extensive array of evidence presented. That's precisely the reason why he shouldn't be allowed to utilize it against Andel in this particular situation. If the Leveson inquiry documents were permitted to be used, it would absolve Harry's legal team of any effort, making it inequitable. I believe that this case is destined to fail in several respects. Let's wait and see what unfolds on the 21st. That's it for the video. Please share your thoughts in the comments. Don't forget to like and share with those interested. If you haven't already, hit the subscribe button to stay updated with our latest content. Thanks for joining us, have a great day, and stay tuned for upcoming videos.